In 1917, when the United States entered World War I, there was great opposition throughout the American populace about our entering the war. Many people felt that we had nothing to gain by fighting this particular war, which solely involved conflicts among the European nations. And indeed, Woodrow Wilson had been reelected president in 1916, in no small part with the claim that he kept us out of war. Nonetheless, after being reelected, Wilson decided that we should go into the war and went to Congress and got a declaration of war. But the problem he faced was that many of the American people thought this was a terrible idea, did not want to lose their lives or their sons' lives fighting this war, and therefore there was great opposition. Wilson therefore led the Congress to enact first the Espionage Act of 1917, which among many other things made it a crime for any person to obstruct the draft or the war. And the question was how that applied to speech that criticized the draft of the war. So it did not expressly say that. Most federal courts interpreted the Espionage Act as prohibiting speech critical of the war or the draft. And many people, thousands of people, were put in jail because they criticized the war and the draft. But a couple of judges took the position that that's not explicitly what the Espionage Act said, and that merely speaking against the war and the draft, criticizing the government for entering the war, was not sufficient to justify criminal punishment under the Espionage Act of 1917. Therefore, Congress enacted, with Wilson's approval, the Sedition Act of 1918. The Sedition Act of 1918 went further and made very clear that it was a federal crime punishable by up to 20 years in prison for any person to criticize the war or the draft. This was a dramatic shift in American efforts to suppress free speech, not unprecedented, but nonetheless a dramatic shift. And again, thousands of people between the Espionage Act of 1917 and the Sedition Act of 1918 were criminally punished, put in jail, or even sent out of the United States because of their criticism of the war and the draft. This was a fundamental challenge to free speech in the United States. And when these cases came before the Supreme Court of the United States, the court, distressingly, basically said that these statutes and these prosecutions did not violate the First Amendment, which provides that Congress shall make no law abridging the freedom of speech or of the press. They found that in these situations, the government's interest was sufficiently great to justify punishing people for this expression. And that remained the law for quite some time. The Sedition Act was repealed in 1920 after the war ended, but the Espionage Act remains on the books to this very day. Over time, the Supreme Court has come to recognize that it made a terrible mistake in those World War I cases, and today has adopted a much more aggressive understanding of the First Amendment that essentially says that criticizing the government or the war or draft or policies of the government cannot be made a crime unless the speaker expressly advocates criminal acts, and that those criminal acts are likely to occur imminently and to be grave harm to the government. So we've come a long way since World War I, but the Sedition Act posed a low point in the history of the United States in its understanding of and protection of free speech.